Earlier, you may have seen part one of this interview with Kyle Singhal, the appellate lawyer from the firm Hopwood and Singhal in Washington, D.C. Now we're going to continue with part two because I know that there are limitations to how long these videos can be for the videos that I publish in prison. So here's part two. So for those in our audience who are not familiar with the judicial system, we have three tiers of courts really in the federal system, which is the district court judge, and those are the people that are determining the issues of fact. Then you have the circuit court judges, which are where you worked, Kyle, and that is really, you described it as the lower court. So it's really assessing whether that lower court complied with due process, or am I correct in that?
Yeah, well, right. So due process can be part of it. Right. The trial courts where folks go to usually have a jury trial or where they make a guilty plea to the judge. Those are called district courts, like you said. And when you're sitting on a court of appeals, the judges there, they consider themselves lower than the Supreme Court, but they use the term lower court at their vantage point to refer to the trial court. And it's typically the role of an appellate judge is to find errors or abuses of discretion that were made by the trial court and then determine whether those errors, if they exist, warrant reversing the outcome and either sending it back for a new trial or in some cases simply reversing the verdict and ending it there.
So everybody has, now correct me if I'm wrong, or I should probably just ask you the question. My understanding is that every individual has a right to go to that intermediary court, the circuit court, but not everybody has a right to go to the highest court in the country, which is the Supreme Court. Could you explain if I'm accurate in that and what the process would be to advance if you didn't get the outcome you wanted at the circuit court level?
Yeah, that's right. Almost everybody has the right to go to the circuit court. Certainly everybody who has just had a jury trial has the right to appeal to the circuit court. In some cases, if you've entered a guilty plea, you may have waived your right to an appeal. And absent some reasons why you should be able to withdraw that guilty plea, you then wouldn't be able to appeal. And there are some other claims related to immigration, et cetera, that are not always appealable at all. But for the most part, you have this right to appeal to the circuit court. But with the Supreme Court, essentially no one has the right to petition for review in the Supreme Court. There are a handful of cases some relating to elections or voting or whatnot that do essentially have a mandatory review in the Supreme Court, but those are special and fairly uncommon. Instead, you have to file a petition for a writ of certiorari, and those are not very frequently granted. It's typically a few dozen cases a year that are actually heard, argued, somewhere in the neighborhood of 70 or 80 at most these days. And there are other cases that are decided on the papers by the Supreme Court, but it's very uncommon to receive hearing, let alone win a Supreme Court case.
So given your extensive experience in reviewing lower court rulings, both as a clerk and in your career, I take it that your area of expertise or the place where you enjoy working the most is on appeals. Is that right?
Absolutely, 100%.
And what options do they have after they've had a verdict of guilt and they want to say, oh, I'm not happy with the justice that I received. I want to pursue something else. What options do they have?
Yeah. Well, it's really, I think there's like a 5-part approach here. So first, as soon as the jury returns the guilty verdict, you file what's called a Rule 29 motion or a motion for a judgment of acquittal, where you're asking the judge to say, those jurors could not reasonably have returned a guilty verdict. Judge, as a matter of law, I want you to reverse that verdict. And that's very uncommon for the judge to do that, but that is sometimes successful. You may also ask your lawyer to file a Rule 33 motion, which is a motion for a new trial. The standard for winning that is a little less onerous than what I mentioned about the Rule 29 motion. Essentially, if the judge, as a 13th juror, would have come out the other way and found you not guilty, then the judge can order a new trial. Of course, you have to go through a new trial. So that's item 2. Item 3 that we sometimes will help with is a motion for bond or continued release pending appeal. And that's not an attack on the conviction, but it's certainly part of a package that we would propose that someone consider is they file their motions for new trial. They also file a motion for continued release if they're out on bond already pending appeal, so that while their appeal is going on, which can be a year or two or more, they get to enjoy their freedom and remain at home. And then comes the appeal. And so the appeal is primarily done on the paper, but there is an argument almost always after a jury trial. The appeal will carry an argument. And then if that's not successful, then after the appeal, there's sort of part 5 would be a handful of final attempts. And so that would include in the Court of Appeals, you would ask for rehearing by the same panel that decides your appeal. You would ask for rehearing en banc by the full Court of Appeals, by all of the judges on that court. You would file a petition for certiorari for review by the Supreme Court, if that's appropriate. And then you would try post-conviction review in the district court, which is a whole separate set of filings. And so all of that could come after if the appeal is unsuccessful.
So when you were speaking about the Rule 29 and the Rule 33, I think it's important for our audience to understand these are for people that went to trial, people that pleaded guilty or accepted a plea agreement. Would they have access to those Rule 29s? No. Okay. So that's an important verdict. And you'd also mention an en banc hearing, which is really interesting. So in the circuit court, there are only 3 judges, it's my understanding, that hear the appeal. What is the difference between this 3-judge panel that hears the appeal as contrast that with the en banc hearing? Right.
So the general rule is that a 3-judge panel hears the appeal, and the 3-judge panels are drawn at random to decide 1 or 2 days worth of cases, essentially. The panels of judges are constrained to follow precedent. Whatever the previous rulings of the Court of Appeals say on a particular issue of law, the panel must follow. Now, sometimes you'll have a prior precedent that the panel, perhaps expresses that they disagree with, or there might be a prior precedent that other judges who are not on this panel don't want to see applied. For any number of reasons, after a panel circulates a published opinion in a case and before it's final, any of the judges on the Court of Appeals can request a vote of the other judges to decide whether to go ahead with an en banc hearing where it depends on the court, all 10, 15, 16 judges will hear the case and just do a rehearing. And if a majority of the active judges on the court agree to rehear the case en banc, then they'll simply vacate the panel's ruling and they'll have a new argument, and then whatever a majority of the en banc court decides to do becomes the outcome of the case.
So Kyle, thank you so much for giving us that backstory on appeals and the importance of appeals. But let's talk about somebody who may really be pre-conviction. He may be pre-charge. He may be he hasn't even had a finding of guilt yet, but he understands the possibility as it exists. Does it make sense for somebody at that early stage to retain a law firm like yours to be talking about sentencing or potential appellate issues? And if so, how does that process work?
Well, it certainly can make sense to have a second set of eyes on filings. I think we worked with a lot of trial lawyers, and they're great trial lawyers. And it's as a necessity of these great trial lawyers become very well versed in the facts and details of the case. And that's super important in being able to communicate with the judge and potentially a jury and with the prosecution about the case. But I think where we have added value is just as a second set of eyes to ensure that one of any issues for appeal are being preserved and are being argued in an effective way in the district court, so that when the Court of Appeals reviews the transcript, reviews the record, they will fairly confront the issue in the way we'd like them to.
And No, so that's very helpful that people should be thinking in terms of always, the strategies or the seeds that they can plant today, for almost like an insurance policy in the sense that if somebody does have the resources, it probably makes sense to bring not only a second set of eyes, but a set of eyes that specializes in appeals. So maybe there seeds that as part of a strategy that if this doesn't work out this way, we've got something to look forward to this way. Does that make sense, or is that a waste of time?
No, I think again it obviously is time and money, and it can make sense when there's reason to suspect that an appeal is likely, and in those cases, again, I think the primary benefit of having an appellate shop helping out with the trial team would be to review the paper filings, not to attend every hearing and status conference, etc., but to review the filings that are going in the docket, and potentially other pre-trial drafts, etc. And that way also the appellate team can have a head start and get a sense of the government's hand and how to frame and brief the issues when it comes time for an appeal. One of the challenges with an appeal is often the timing. The trial can go on for years with all the pre-indictment and indictment process, and then everything else, but often the appeal is initially due within months of the jury verdict or sentencing, and that can all happen very quickly.
As I mentioned, a lot of people that are viewing the Prison Professors program are in jail in prison, and they may need to hear a little guidance from you, to the extent that you're able to provide it, with regard to administrative remedy and what role that can play in a person's potential litigation going forward. What is the administrative remedy process in jails and prisons?
Well, typically, I think you're referring to grievances, right? When someone has usually a problem with their conditions of confinement, they would need to pursue the grievance procedure all the way to its end and make sure that they're reading the rules on how to appeal those determinations. And if you don't follow those procedures fully, then you might not have the right to bring your challenge to court. And so typically before you could, bring what's called a 2241 motion or petition in a federal court to challenge your, perhaps the calculation of your sentence or something like that, your award of good time credit, you would first need to follow the administrative procedures. We also see that come up in the context of the First Step Act. I don't know if you wanted to talk about that.
Sure. I'd love, that is one of the questions that I wanted to talk about, but also even just differentiating between the structural, I think, mechanism of a 2241 versus a 2255.
Sure. Well, and I will say we do more with the 2255. That the 2250. You hear these numbers, and they're not like incantations, like you just speak them and something happens, right? But they're the section code, the section number in the U.S. code, and so section 2241, as I mentioned, is for more challenging the execution of your sentence, and whether it's conditions of confinement or calculation of a sentence, or more procedural matters like that. 2255s are your standard habeas corpus remedy for a federal prisoner who is challenging something like ineffective assistance of counsel. That's probably the most common basis for a 2255. It can also be used for newly discovered evidence and a few other things, but often what you may hear is someone who is upset that their lawyer didn't make a certain argument when they went to trial or even on appeal. And so the 2255, you have 1 year from the finality of your conviction to file this 2255. That goes to the same judge that sentenced you. And if the judge denies your requested relief, which typically you would be requesting a new trial or something like that, then you would ask that judge for a certificate of appealability so that you could then appeal his denial or her denial of your 2255 back up to the circuit court. So it's almost like a second bite at the apple, but typically it's for just a few different matters like ineffective assistance of counsel, claims that your lawyer reasonably should have made an argument or done something for you that he didn't do.
And so you'd mentioned this timeline of 1 year from the time a case is final. When does the court consider a case has become final?
I think we'll probably take the L on that one because that's probably a little more complicated than I want to answer on this.
Okay.
So, yeah, sorry, I could have probably given you a good answer.
No, that's all right.
Yep.
How about a second question?
Sure.
Sometimes when the person is out of time with regard to that 1 year time limit, we've heard of some esoteric writs like the writ of quorum nobis. Could you give us any insight on what a writ like that is or what it does?
Yeah, I think what comes to mind, this is something that you don't see too often, is habeas corpus only applies to someone who is in custody. So a writ of quorum nobis, I think technically, can be filed by someone who is out of custody. And it's another way to have a petition go before your sentencing court. I believe this all goes back to the All Writs Act and the Judiciary Act of 1789, that it allows you to file more or less any writ at common law. But that's not something we see too much